Okay, this is part two. It won't be as long as the first part, but I'm going to continue with finishing off on the universal structure and then move into universal substance and what it means to have, what universalism actually means. So I'm going to cast now the invitation. So we started, we ended off in the last session with the universal structure. I'm just going to finish off a little bit on the universal structure, how that impacts, and that will lead us into the universal substance. So this universal structure creates a universal democratic space. And what Ignatieff had acknowledged was that social movements, that NGOs and individuals are very influential. And so these are just some examples of social movements that have pushed the most significant contemporary issues. And this universal democratic space, this structure, how does it operate? Well, it has the power to work against states. In this case, in 1995, when France was testing nuclear weapons in the South Pacific, a campaign against French wine pushed France into signing the nuclear test ban treaty. So we have this social power working against states. It can also work indirectly toward states as a whole by working toward their regions. In the European Union, there was a lot of pressure put on the European Union to address the death penalty in the United States. And attempts to address the death penalty directly to the federal government were not successful. The federal government didn't want to have anything to do with it. And so the European Union has targeted the individual states who execute the most individuals, have targeted them directly, Texas, Virginia, Georgia, to name a few, and targeting them with both pressure and also economic sanctions. And then those states then in turn pressure the federal government to address the situation. So social power working against regions within a state. Social power can also work on a very local level. In this case, this was a case to the Committee on the Elimination of Racial Discrimination, attached to the Convention for the Elimination of Racial Discrimination. And in Australia, there was a grandstand, and the grandstand was called the Nigger Brown Stand, named after this individual who was a rugby player who had a nickname after a shoe polish. And what the committee in that case said, when this individual, Stephen Hagen, he brought a case, and the committee said that the convention is a living instrument that must be interpreted and applied, taking into consideration the circumstances of contemporary society. So this universal structure then looks at what is the situation of the contemporary society. And in this context, the committee considers it to be its duty to recall the increased sensitivities in respect of words, such as the offending term appertaining today. So it looks at what is the situation today, what is the local situation there today, and in that case, it said that the sign had to come down. This is a very recent case. It shows the social power against also organizations. In this case, an American football team. The National Congress of American Indians has fought for a long time to get the name of this football team to change, change its name from the Washington Redskins to something else. They consider what they call the R word to be a racist slur. And not so long ago, the owner had said that you can put it in capital letters. I will never change the name. He was very specific. Well, the pressure was then put on investors, particularly in light of the recent situation with racial relations in the US and relations with minorities. And so pressure has been put on investors, and the investors, representing $620 billion worth of investments, then put pressure on the sponsors of the Washington Redskins, Nike, FedEx, Pepsi. And then those corporations then put pressure on the team saying, well, you need to change it now. And now that it was released that they, just a couple days ago, that the team would change its name. So just examples of social power having an effect on states, on regions, on local towns, on organizations at all levels. So this universal structure, this universal democratic space is then pushing what it defines to be the universal substance, and achieving those results as well. Results are not always achieved, or the results of what civil society might be pushing are not always achieved. And in this case, of course, the Iraq War in 2003, the United States presented evidence at the Security Council. There's an interaction of many different entities within this universal structure in a universal discourse. And so the evidence presented at the Security Council and significant protests all around the world against this war. But then eventually the US president, he declared diplomacy has failed. We will proceed with a coalition of the willing anyway. Something that, if you remember from my little story about ancient Greece, they would think that yes, the strong doing what they can, the weak suffering what they must. But afterwards, Kofi Annan, the Secretary General, he observed that from a charter point of view, this was illegal. And even Colin Powell, who had presented the evidence, he said, yes, I regret the UN speech that I gave. It was not accurate. And although the social power didn't win out in this particular case, the documentation of it, having to put this all on the record, in 2,500 years ago, Athens, they did not have to declare why they were doing this or give any sort of justification that could then be undermined afterwards. In this case, the attempts at justification, the open analysis that this was illegal, and the undermining of the justification, then adds something to the dialogue in the future, adds something toward working toward a consensus, a substantive consensus afterwards. And as I did with the national assemblies, peaceful protest, peaceful resolution of social conflict isn't always the case. Here, the protests against the World Trade Organization in 1999, which were quite violent. And so it doesn't mean that conflict ends. Conflict, of course, continues in many different ways. But a structure is created, and in this case, there were significant changes made to the way globalization was being created at that point in time, and the way that the World Trade Organization was being run, and the World Bank and the IMF as well. So the documentation and the case itself is a way to move the discourse forward, even if at the time it may seem to have been ineffective. And so what is this discourse? Well, going back to that example of ancient Greece again, ironically enough, President George Bush Sr., he said that a new world is struggling to be born, a world where the rule of law supplants the rule of the jungle, a world with a strong respect to the rights of the weak. Kofi Annan, a similar quote that he said that the multilateral institutions give the poor and the weak influence over the actions of the rich and the strong. And so these universal structures create a universal discourse that can move toward this goal, this objective, where the strong cannot just do what they want and the weak suffer what they must, but where there is substantive universality. So these cases, every case, every instance, every situation in this enormous, complex universal structure with universal discourse. All of these are cases, are points of reference along the road toward human rights. It doesn't mean that progress will always be being made down the road. It could be that progress is lost and is returning away from the enjoyment of human rights. But all of these issues, they contribute to the long-term perspective. And when we talk about the road of the human rights regime, what has the road accomplished? Have there been any progress? And these are just, I thought it's important to show that there has been progress. There has been progress in a number of different ways, a number of substantive progress on poverty and democracy, conflict, deaths, life expectancy. All statistics show going in a good direction. So if we think about this road, there has been progress down the road. And the documentation, the discourse that goes on that road is making some progress. Goes forward, goes backwards, hopefully. And what these statistics show is that there has been, over the long run, there has been progress. So Michael Haas, what has he said? The object of the discourse is that most progress has been through the political process rather than through the litigation based on rights. And the implementation of the new legal norms must rely ultimately on voluntary compliance, which is easier to achieve when justified in moral terms by legal principles. Now, what does that mean? That means that the object of this discourse, while it's a universal structure toward universal standards, the best way to get there to be an acceptance, a consensus of these universal standards is to have a process of discourse, to have a process by which individuals can analyze the situations and internally decide whether or not they're going to, whether or not these human rights are, whether or not the substance of these human rights are universal. And just to demonstrate this type of enforcement, this internal enforcement, this internalization of human rights through this universal structure, and which creates universal discourse, which enables internalization, because internalization is the only way to really enforce human rights. You can't have a human rights police officer on every state and on every individual in the whole world. Ultimately, states have to understand, and states have to think, well, they want to fulfill human rights, and that individual people want to do the right thing. And that's the only way to really achieve that objective of full enjoyment. So sort of a funny little example of that is, what keeps someone from stealing a pen? Well, is it that it's illegal? There was a funny case where the president of the Czech Republic, he stole a pen. It was on video. It's not on YouTube if you want to watch it. Very comically, thinking he was very clever, just kind of slid it into his jacket. And what really stops people from doing something that is illegal? Is it that there are police right there to stop you? Or is it the shame that you don't want to be looked at poorly? Ultimately, what you want, the only way to really enforce human rights, in a sense, is if they're internalized. And so this universal structure creates universal discourse on this road toward enjoyment to attempt to create the internalization of human rights so that enforcement happens, self-enforcement happens. And self-enforcement means a consensus, moving toward consensus on the substance of what human rights are. Another example of this is, I thought I'd share a personal story on what is the effective means of attaining internalization. There, of course, you could bring a case to a court, and you win the case, and you as an individual might be very happy that you won a case, but the other side, they might be thinking, well, I lost that case and I disagree with it greatly and I don't think it was a good idea, and they haven't internalized it. And the adversarial system is not always the best way to internalize things. And an example of that, when my firstborn, I had moved to Norway and my firstborn was expected, and we knew he was going to be a boy, and we were at a hospital in Norway, in northern Norway, a rather small hospital in a remote area. And we were visiting the hospital just before he was born. He was expected to be born in a couple of days. Something I hadn't thought of was in America, where I grew up, it is more common that boys are circumcised. And so I just asked the question, oh, do you do circumcision here? I hadn't really thought about it very much. I hadn't critically analyzed it in any sort of critical analysis. And the response that I got from the nurse was that I was basically a barbarian to even think about such a thing, and they don't do such barbaric acts there, and that was completely terrible. And the nurse made a very big deal about it. My initial reaction was a negative reaction. It didn't help me internalize it at all. I internalized it later on when I considered it in a critical analysis of the issue. But standing there banging someone over the head saying, this is what you must do, that's not a way to internalize something. You need that. You need all of these universal structures that create the universal discourse in order to create the universal internalization. Because it's only through that critical analysis, through that discourse, that you're going to get internalization. It's not effective to do it in an adversarial type of way. So that is what that road forward, that is what all of these universal structures are aimed at. So I've said a lot about what is discourse, and now we're starting to move into the substantive standards. So when I say what is discourse, discourse is, as Jeremy Waldron is saying, we should stand accused of the stupidest, most arrogant form of moral imperialism if we were to swagger around trying to impose our way of life without sensitivity, confronting the basis of other people's and other cultural resistance to it. So he's saying we can't go banging people on the head. And Michael Ignatieff, he says that the fundamental moral commitment entailed by rights is to deliberation, requiring a willingness to remain in the same room, listening to claims one doesn't like to hear. So this discourse means being open-minded of all views, not saying, I have my substantive belief of what is right and what should be the standards, and I'm not going to change it. What is required is we have the universal structure, which creates the universal discourse, and you have to participate in the discourse. And the whole point of this universal discourse is, as Jeremy Waldron said, the objective is what is good in the absolute, not what is relatively good. The argument is with other universalists about the content of human rights, not against relativists. What he's saying is that what this discourse is aimed at is universal substance. It's not relative substance, it's universal substance. That's what the discourse is aimed at. Here are some authors being very critical of local relativity. In an analysis of the genocide that occurred in Rwanda, Scott Strauss and Lars Waldorf, they said that substituting local understanding with universal human rights categories can lead to very dangerous appraisals of the situation. And similarly, Mark Goodale, he said that reversal of the primacy of the global for the primacy of the local is a romanticization of all things local. So critical of relativity. So the objective here is universal substance. The objective of the universal structure is to arrive at universal substance. As Xiaodong Li said, there are minimal shared beliefs. Genocide, slavery, racism, and are wrong. And this is going to what is the substance? And these authors are saying there's a universal core of substance. So Judith Sklar said what we have to think about is the cruelty that people experience. That's what is the core. That is what's universal at this point in time. And Ignatieff, he also says that human rights must remain very minimalist, and his minimalism is not strategic, it's just all that we can hope for. In reality, that's all he understands that we can hope for. It's all that, even with all the structure that we have and the universal structure and universal dialogue, all we can really hope for is a very small core of substance. And one of those core aspects is often said that, well, everyone agrees that torture is not a good thing. We can agree that that's a universal substantive standard against torture. But as the circumstances after the September 11 attacks in the United States displayed, even torture can have its fallbacks. And so this universal substantive standards are not static. They can change over time. And here are just a number of US officials basically justifying why torture in these particular circumstances is okay, demonstrating how even the most hardened core of substantive standards can erode over time. So it's never static. And what the good thing is here is good as far as the human rights standards and moving the human rights standards forward, is that the universal structure rejected these claims greatly, and the universal dialogue from that structure rejected these substantive claims greatly. So Ignatieff again, he says that the universal core of substance is this: to protect human agency, not cultural conformity. Rights are universal because they define the universal interests of the powerless. They must create conditions in which individuals on the bottom are free to avail themselves of such rights as they want. What matters is that people who are making claims are the victims themselves. So he's talking about agency, that individuals need agency in order to be able to advance their own claims, in order to be able to decide for themselves what they want to be and what they want to achieve in their lives. What Jack Donnelly has said about agency, human rights assumes that people probably are the best suited and in any case are entitled to choose the good life for themselves, to choose what they think is the good life. So when it comes to agency, if that's the core of the substance, what is required of agency, to have agency? Well, probably the key rights for agency are the freedom of expression and the freedom of thought, conscience, and religion. Articles 18 and 19 of the Covenant on Civil and Political Rights. Because to have agency, one needs to receive information, and that's the essence of the freedom of expression, is not only to express, but also to seek information. And by seeking information, one can formulate thoughts, conscious religion, which helps define what someone defines as their good life, what they want to achieve in their life. So FORB and the freedom of expression are maybe the key rights for agency. But can we really limit agency to just these rights? If we look at agency from a capability perspective that Amartya Sen writes about, then we can see this is just a small sampling of what would certainly be needed, that people would need to enjoy some equality, an ability to work, adequate standard of living, good healthcare, some education, and only with that can you reach the level that you have full capability to decide what is what you define as the good life. So agency could be anything from very simple, very core elements of freedom of expression and freedom of religion and belief, to all human rights in order to have agency. But talking about agency, the substantive standards say, yes, everyone has a right to decide what they think is a good life, but at some point it ends. At some point, agency is not unlimited. And in this case, there's a strange sport, I guess you would call it, a spectacle called dwarf throwing, where people they pay a dwarf to come, and they compete to see how far they can throw the dwarf. And so this was this practice, it has been outlawed in many places, but it was outlawed among others in France. And the dwarf, a dwarf involved, he said, no, I want to continue doing this. This is my livelihood. This is what I want to do. So his agent, in exercise of his agency, he said that's what he wanted to do. And the court in France said, no, you cannot. And the Human Rights Committee, attached to the Covenant on Civil and Political Rights, agreed that the prohibition is necessary to protect public order, which brings into play considerations of human dignity. So we here see that word human dignity pops up again. So some hint to this general concept of dignity, and that people will not be allowed to violate their own dignity. So this same general holding could be applied to someone who would not be able to sell themselves into slavery, for example, because that would be against their own human dignity. Jack Donnelly also has a theory he calls weak cultural relativism. And by that, he means that there is a comprehensive set of prima facie universal human rights that permit some measure of local exceptions and variations. So each human right has a core to it, but exactly what each human right means, what each substantive standard means, can have small variations. So as you see in the top line there, I call this universal light substantive standards. And another type of universal light substantive standards. These authors have said how universal standards need to be read in particular circumstantial contexts. So human rights may have universal standards, but they are always experienced locally in particular times and places. Human rights require grounded contextual analysis. And that overplaying the universal in place of the local has quite serious negative repercussions on the ground. So that it is important to take in the specific considerations on the ground. And I'll address in just a moment how that's done. So who ultimately decides the standards? How is that done? David Forsyth reminds us that it is the legal system that tells us at any given point in time which rights are most fundamental in society. And reminder of Hart and Raz that we have that the legal system, this legal matrix that has been created, that it forms a way to resolve social conflict. And the resolution of that social conflict is we look to certain authorities that have been given the ability to resolve the social conflict. So who is that in this universal system? Well, the treaty bodies are the main arbiters of standards. Each treaty body attached to a specific treaty, they are able to, among other things, give views on particular cases. And the Human Rights Committee has said that there's a right to an effective remedy based on Article 2.3 in the Covenant on Civil and Political Rights. And what they have said in their general comment number 33 is that the views of the committee under the optional protocol represent an authoritative determination by the organ established by the covenant itself, charged with the interpretation of the instrument. And so it is these committees that are the ultimate arbiters. So there's this enormous process of universal structures and universal discourse, but ultimately, if there is no consensus, if no consensus is reached, it is the committees who decide, make the ultimate decision. So here's an example of a treaty body making such an ultimate decision. This was a case that originated in Norway, and it was based on the Norwegian school curriculum on religion. And it was brought to the Human Rights Committee attached to the Covenant on Civil and Political Rights, and it was decided according to Article 18 on the freedom of religion and belief. So there was a course on Christianity, on religion, and other worldviews. And the course was criticized because the curriculum of the course, the subject gives priority to tenets of Christianity over other religions and philosophies of life. And the curriculum was not presented in a neutral and objective way. It is a indoctrination of religion, not about religion. And because of that, it was found to be a violation of Article 18. It wasn't that the Human Rights Committee was going to say, okay, well, it's a Christian country, and so all of the students are, it's their freedom to be educated in Christianity. No, it's their freedom to be educated in a neutral way, so they have the ability, so they have agency to decide for themselves what they want. If they choose, after having the ability to have agency, they can then choose to adhere to a religion. But to teach them in the schools in this way, in religion rather than about religion, was an indoctrination rather than liberation, or liberation is not the right word, but the facilitation of agency. But in the end, it was the Human Rights Committee that decided. And so the Norwegian school curriculum was changed as a result. So I should just say too, in the Human Rights Committee, they look at it as the Human Rights Committee decides on its own, is this within the substantive standards or not? And if it's not, it's a violation. It's a violation of the substantive standards of human rights, and the state is then required to change it. In the European Court of Human Rights, there's a different approach, what's called a margin of appreciation. And the margin of appreciation gives some leeway. What we saw, some of the scholars previously had said that you need a contextual, local context of the interpretation of it. It doesn't mean that the right itself becomes relative, but the context in which the details of the right can be contextual to the specific circumstance. But even within the margin of appreciation, however, there's a progressive understanding about what is the broader norms, not just the local norms, but the broader norms. So just as an example of this, in 1986, a transgender person wanted to change their birth certificate, and the European Court found that to require the United Kingdom to follow the example of other contracting states is, from one perspective, tantamount to asking that it should adopt a system in principle the same as theirs for determining and recording civil status. So and in that case, the transgender person was not entitled to the new birth certificate. And what the court in that case was saying was that the local context was, I'm not going to say that it was relative, but the local context was catered to the way that the local social norms looked at a certain specific situation. But 15 or so years later, in 2002, a similar case came to the same court, and they found differently. They said that since the convention is first and foremost a system for the protection of human rights, the court must have regard to the changing conditions within the respondent state and within contracting states generally, and respond, for example, to any evolving convergence as to the standards to be achieved. So when we talked about that road toward a convergence, when that convergence starts to be achieved, then the local contexts are no longer sanctioned by the court, are no longer allowed to continue by the court. Then the convergence of universal standards is then applied to the court. So in that case, the court proposed, therefore, to look at the situation within and outside the contracting state to assess, in light of the present day conditions, what is now the appropriate interpretation and application of the covenant. So those evolving standards can also be applied locally, so that the local has to adapt to what is the consensus on the substance. So there's a universal structure, and the universal structure creates a universal discourse, hopefully working toward internalization at every level, even at the individual level. But at some point, because these are individual rights, at some point, then the court is the one that decides, in this case, the European Court and other in the international system, mostly the treaty bodies, that decides, well, now an individual person their rights are being violated. And when there's a convergence of norms, then that's not allowed. It will not be tolerated. And where do we get this convergence of social norms in the legal system? Well, if we look, for example, in the Committee on the Rights of the Child, which is attached to the Convention on the Rights of the Child, the General Comment number 8, they said that the Convention, like all human rights instruments, must be regarded as a living instrument. The European Court has used the same terms, this living instrument. And so the social norms within, the understanding of the norms within the treaty evolve over time. And what may at one time have been allowed under the treaty may at a later time, as the norms in the entire region or universally with the universal treaties, as they evolve, then once a consensus is reached, then that consensus is applied to all states. And then, as the Committee on Economic, Social, and Cultural Rights have said in their General Comment 9, then all those states are then required to implement those substantive standards and to change social norms within their state. Something that a number of authors, including Peter Sparrow, he has said that there's a bit of a bait and switch going on here, that states sign up to this universal system, never realizing how universal standards are going to be applied to them. But it is a universal system, and that's the whole nature of the system. Universal structure creates universal discourse, which works toward universal substantive substance. And it's that universal substance that eventually and inevitably is applied by there's a certain treaty mechanism that decides. That's what law is about. There is finally, at the end, someone who will decide to end the social conflict, at least in as far as the legal matrix is concerned. And finally, then, I'll just leave with there's a book by Thomas Risa and others called The Power of Human Rights. There's a second edition called The Persistent Power of Human Rights. And he has an entire theory, it's called a spiral model, of the way the local, the individual, and working in cooperation with civil society can claim their rights against the state. And then all of this universal structure then operates to help that individual achieve their human rights. And what happens is once the state engages in this discourse, because the state has been made part of this universal structure, once it is engaged in the universal discourse, it's what he calls entanglement discourse. Once the discourse starts, then it works its way toward, usually works its way toward growth of human rights, toward a consensus of human rights, toward the universal substance. And so it's the universal structure that works toward the universal substance. As he points out, going up the spiral toward enjoyment or down the road toward enjoyment, it's not always progress. Sometimes there's regress, but this is one model, one way to reach the universal substance through the universal structure. So with that, I will say thank you very much. And there's when you get this on the last page of it, you'll see that there's ways that you can find some links to information, and this PowerPoint will be distributed to you, and it will also be available online at this website. You'll be able to find your way to where you can find it. So thank you very much. I look forward to discussion.